So let's talk about the next segment. Okay, let's talk about the Slaughterhouse case. Now, this happened in 1873. Some people, now remember we were talking about jurisdiction. I talked about jurisdiction in the beginning. Some people were talking about, we'll talk about how this gutted the 14th Amendment, but did it really? Okay, because, and I'm gonna show you, I'm gonna give you a little bit of insight that isn't really covered by legal scholars, but this is also where the freeman ideology comes from. So in 1869, the Louisiana legislature handed one company, the Crescent City Livestock Landing and Slaughterhouse Company, a 25-year monopoly over all slaughtering around New Orleans. Every other slaughterhouse had to close. They gave it a monopoly. Now, in I think it was 1907 under Teddy Roosevelt, and the monopoly laws and the oh god, there's I can't antitrust laws. That was to be able to combat something like this, okay? Because you're gonna, and you'll understand why here in a minute, okay? So roughly 1,000 independent butchers now had to bring their animals to one company's facility and pay its fees. Their organizations, the Butchers Benevolent Association, sued. So think of it like this: you can only go to Walmart. You cannot go to Target. You cannot go to Sears. You cannot go to Michaels. You have to only go to Walmart. What would you say to something like that? Now you're a butcher, or you're a business, and you butcher, and so now you're competing on price. Now all of a sudden you got a monopoly. Do you need to compete on price? No, you can charge whatever you want. You can require any fees. You can require all kinds of stuff. It gives one company complete control. That is the whole reason why the antitrust acts under Teddy Roosevelt were so important. Okay, so 1,000 butchers were put out of business because of this. So their argument was that the monopoly stripped their privileges or immunities as U.S. citizens, specifically the right to work a lawful trade, and even amounted to involuntary servitude under the 13th Amendment. Now, here's the thing: as we looked in the 1833 case, it said that the Bill of Rights only applies to the federal government's application to state citizens. It does not apply to state laws. So if the federal government outlaws slavery, it does not mean that the states outlaw slavery. Okay, so just in this same point in time in 1873, you still had two classes of citizens. You had those that still had their state citizens rights, okay, because it wasn't until like 1878 that the federal government actually takes back over immigration. But you still had state citizens, and this was a state's right. So they were still respecting the 10th Amendment at this point in time, which was anything that wasn't given to them in the Constitution was remanded to the states, and they were able to keep their rights and to be able to govern how they saw fit. And this was done on a local issue. This had nothing to do with the federal government. Now, people will say that this stripped rights because because of the dual citizenship, but these people were under a different set of dual citizenship. Their primary residence was that of a state, and they got state residency, and they got looked at that way. Hence, that's why the court held that they could not claim privileges or immunities under the 14th Amendment, because that's the tricky thing. Even though it's an amendment to the federal Constitution, who does it apply to and who does it not apply to? And that's really what the questions that we're answering here. So the court affirmed the monopoly because it was a states' rights issue, had nothing to do with the federal government, nor did it fall under interstate commerce because it was not crossing state boundaries. So therefore, the federal court had no jurisdiction over it. So therefore, they kicked it out and said, "We rule in favor of the monopoly," not because it was legal, but because it was not something that the federal government had the right to be able to govern over. They still recognize the division of powers between the states and the federal government. And so many people like to go, "Oh, well, we want to go back to that." Well, you got to understand it if you want to go back to that. Okay, so Miller's split citizenship into two and said that that the privileges or immunities clause only protected the national kind. Okay, so that means okay, so there is a citizenship of the United States and a citizenship of a state, which are distinct from each other, and which depend upon different characteristics or circumstances in the individual. Miller said that the privileges of national citizenship are a short list: the right to travel to the seat of government, so to come to Washington, D.C., free access to seaports and federal offices, protection on the high seas, the right to peaceably assemble and petition the federal government, and the writ of habeas corpus, i.e., to demand the body. The right to earn a living in an ordinary trade, what the butchers were fighting for, was not on it. That, he said, belonged to the state citizenship, and the 14th clause did not reach it. Again, because they were state citizens, not federal citizens as their primary citizenship. Miller wouldn't reach the clause broadly because of what it would do to the balance of power. Okay, but as I've outlined in jurisdiction and how citizenship worked, that's how this makes sense. Okay, so a broad reading would say that it would constitute this court a perpetual censor upon all legislation of the states, and the effects is to fetter and degrade the state governments by subjecting them to the control of Congress. Now, so many people sit back and say, well, we want the federal government to go back to the rule of law and the Constitution. As you see here, this is exactly what's happening. But because you don't understand how it's being divided and how it's being looked at in the courts, in the laws, is why you're getting tripped up, is why you're thinking all of this is one way or another. So, okay. So the dissenting opinion said this: it assumes that there are such privileges and immunities which belong to the rights to citizens as such, and ordains that they shall not be abridged by state legislation. So the dissenting opinion, because I believe this was a 6-3 or a 7-2 decision, the dissenting opinion said that under the 14th Amendment, what it says is that the state that when the state abridges your privileges and immunities as a U.S. citizen, that the federal government had the right to step in there. But the majority did not believe that the federal government had the right to step in there. So therefore, we have the 14th Amendment. It is being applied. It has been put into law. But there's such a loose and a broad interpretation of it from generation to generation, from case to case, that we've split stuff up and we've confused everybody, and nobody really understands what's going on. And so that is really the big part about the 14th Amendment.